Hello, welcome once again. Emmanuel Asiriwa, U.S. immigration lawyer practicing in all 50 states and around the world. If this is your first time of coming to my channel, I encourage you to please hit the subscribe button below. What happens where a child becomes 21 while the petition filed by their parent or step-parent is pending with immigration? The first thing you have to understand is that if the petitioner parent is a U.S. citizen, the age of the child is frozen forever. So what that means is if the child is 18 years at the time that the parent filed the petition, that child will always remain a child. In immigration law, a child is a person who is under 21 years and unmarried. So if you file a petition as a U.S. citizen, your child will always be a child. We have had cases where immigration disagree, and sometimes immigration officers make mistakes. I can't tell you how many times we've seen this type of situation where the child becomes 21 and immigration changes their visa category and put them on a waiting line. What is most important in this case is that a child, if you're classified as a child, you're not subject to a waiting line. So you're an immediate relative, which means that you get your visa really quick compared to people who are on the preference category who have to sit on the waiting line. Now, we had a case where a U.S. citizen filed for her son in Liberia where he was 17 years old. And because for some reason it took forever for USCIS to process this case, she didn't have a lawyer at the time. In this case, it took up to 3 years before it came to us. And what happened was, once the child turned 21, the embassy in Liberia changed the visa category of this child from being an IR2, which is a child of a U.S. citizen and immediate relative, to an F2, a child, an adult son or daughter of a U.S. citizen. That drastically changed the time limit that this beneficiary had to wait. But once we got hired, we filed a case with immigration and argued the law that a child of a U.S. citizen will always remain a child, and we won that case, and the client is happy. Now, if you are a green card holder, your beneficiary are not immediate relatives. So if they're under 21 at the time you file the case, they are considered a child. But if they turn 21 while the case is pending with immigration, immigration would argue that that person is no longer a child. But Congress has seen that this is a problem because it's taking a long time for immigration to process cases. And while the cases are making their way from USCIS down to the National Visa Center sometimes and up to the embassies overseas, these children are getting older and they turn 21. And Congress in 2002, particularly August 6, the law came into effect to help stop this problem, and that law is called the Child Status Protection Act. What is the Child Status Protection Act? Lawyers, we usually call it the CSPA. What the CSPA does is that the CSPA would help a beneficiary child who has turned 21 and is no longer considered a child. With the CSPA law, there's a calculation that can be done to help keep that child's age under 21, and so that the child can still benefit from the immediate relative category. What is the calculation? The calculation is that once the visa becomes available, that is to say, once USCIS has approved the I-130 or the I-140, depending on what case, and a visa becomes current, the calculation that has to be done to determine whether this child's age is still under 21 despite their biological age is to look at the age of the child at the time that the visa becomes available minus the days that it took immigration to process the petition. So for instance, John filed for his son Matthew, who lives in Liberia. At the time John filed the petition, Matthew was 20 years old. It took immigration 2 years to process the petition, but at the time immigration finished processing the petition and approved this person to be a child, Matthew is now 22 years old. under the CSPA law, the calculation would be Matthew's age at the time that the visa became available, which is 22, minus the 2 years it took immigration to process the case, equal to 20 years old. So what that means is that Matthew will still be considered as a child because we minus the days that it took immigration to process the petition up until the time that the visa became available. I know this is very complicated, but if you have a situation where you have a child and you're scared that the child is going to turn 21, or you have a child that you file a case for your spouse and they have a child, a derivative beneficiary child, you can reach out to our office and we will be glad to give you the help that you need. We have fought immigration on this issue in many cases, and we have won all of them because we understand how the calculation works, how the calculation is under CSPA, and we know how to get you to the point that you want to be. Feel free to use the information on the screen and contact our office, and we will be glad to give you the help that you need. I wish you good luck and have a great day.